G'day everyone, this is the fourth video for week 11 of our Legal Ethics and Trust Accounting course. This week we're looking at ethics as they apply to courtroom advocacy. So far we've looked at the duty of formality before the court and the duty not to represent, the idea of having some special favour from the court. We've looked at the duty of independence and we've looked at the duty to make responsible use of the court's processes. In this video, we're going to focus on the duties that a practitioner has in relation to witnesses. The first thing to understand before we come to the duties of a practitioner is, well, we have to understand the duties of a witness. First, witnesses are compellable. A person doesn't get to decide whether to be a witness or not. Sometimes in criminal matters, if a witness refuses to cooperate, a matter might be dropped. But even in those cases, ultimately, if the court issues a summons for a witness to appear, the witness must appear, or they can be arrested and brought before the court. So witnesses are before the court under compulsion. Even if they attend voluntarily, they do so against a background of knowing that they could be summoned if need be. Everyone's heard the form of words used in the witness's oath. They are required to tell the truth, the whole truth, and nothing but the truth. So once a witness is compulsorily before the court, they are then compelled to tell the truth. They are not allowed to omit things, so the whole truth, and they're not allowed to add things to embellish the truth, so nothing but the truth. These are not duties that the witness has to a party. I mean, even in our evidence course, we get used to thinking of a witness as our witness or their witness. And it's true that a witness will be called by one side or another. For instance, you usually can't cross-examine a witness that you call. So it can be natural to think of witnesses as belonging to one side or the other. However, this would be a mistake. One of the most famous judges of all time, Lord Denning, set the principle in a case called Harmony Shipping Company against the Saudi Europe Line, in which he said, "There is no property in a witness. The reason is because the court has a right to every man's evidence. Its primary duty is to ascertain the truth. Neither one side nor the other can debar the court from ascertaining the truth, either by seeing a witness beforehand or by purchasing his evidence or by making communication to him." So witnesses belong to the court. They might be called by one side or another, but the witness has no duty to the party that calls them. They have duty only to the court. And that duty, famously, is the duty to tell the truth, the whole truth, and nothing but the truth. Now, there's no rule that says you can't meet with a witness prior to the trial to discuss the evidence that they're likely to give. This is referred to as proofing a witness or conferencing the witness. It's not always necessary, but in most cases, I certainly like to meet with my own witnesses, and I like to be very clear about the evidence that they're going to give. I don't like being surprised in the courtroom. Even more interestingly, though, there's no rule that prevents you from meeting with your opponent's witnesses prior to trial. And this makes sense because we've just said there's no property in a witness. A witness is not your witness or their witness. A witness is just a witness. So Solicitor's Conduct Rule 23.1 says, "A solicitor must not take any step to prevent or discourage a prospective witness or a witness from conferring with an opponent or being interviewed by or on behalf of any other person involved in the proceedings." Barrister's Rule 73 is almost identical. Rule 23.2 then goes on to make it clear that you can tell witnesses that they're under no obligation to meet with your opponent, but that's as far as you can go. From a practical perspective, however, witnesses who you might consider to be in the opponent's camp, they're hardly ever going to agree to meet with you. So most people don't even bother trying. If you do conference witnesses, it is absolutely crucial that you must never conference two witnesses together. That includes the witness and your client. you should never ever have two witnesses in the same room if you can help it. Even if the whole conversation is perfectly innocent, the situation gives off a distinct odour of collusion. It smacks of the witnesses putting their heads together to get their story straight. And if your opponent learns that it's happened, the first things they're going to ask in cross-examination will be, have you discussed your evidence with anyone before coming here today? Who was present? When they say another witness was present, well, their evidence becomes effectively useless, or at the very least vastly diminished. Solicitor's Conduct Rule 25.1 says, a solicitor must not confer with or condone another solicitor conferring with more than one lay witness, including a party or client, at the same time. Barrister's Rule 70 is set out in the same terms. Now, depending on the court you're appearing in, increasingly these days, you may be required to take an affidavit from a client and to file and serve affidavits prior to trial. In some courts, for instance the Federal Circuit and Family Court, virtually all evidence in chief is given by affidavit. There's absolutely nothing wrong with a practitioner being the one who actually writes out the affidavit. In fact, these days, many of the affidavit forms actually include a field for the lawyer to indicate that they prepared the affidavit. Assisting witnesses in this way helps the court. For one thing, it means that witnesses who are able to express themselves in written language don't obtain an unfair benefit over those who struggle to express themselves in writing. It also means that you can help to make sure that the affidavit only contains admissible material, so that it doesn't become a big screed of opinion or it's not full of hearsay. The challenge, however, is that you have to ensure that the affidavit remains the witness's true evidence. And you have to ensure that the witness understands and truly agrees with every word in the affidavit. Otherwise, disaster can follow. I was once in a matter where an opposing witness used the legal term particularise in their affidavit. When it came time to cross-examine, with my very first question, I took them to that word and I said, can you explain to the court what you meant when you used the word particularised? The witness had no idea what the word even meant. I then followed up. Are there any other parts of your evidence that you don't understand? The judge moved me on, but the damage was done. All of this leads to a broader point. You're not allowed, under any circumstances, to coach a witness in their evidence. There is a difference between proofing and coaching. You are allowed to ask a witness what evidence they intend to give. You are allowed to draw their attention to weaknesses and inconsistencies in their evidence. You are allowed to suggest other matters that they might think about in terms of their evidence. You're allowed to ask them questions to see what they know. You're allowed to have a rehearsal, including a rehearsal of cross-examination. But none of this requires or allows you to tell the witness what evidence they should give or what evidence it would be helpful for them to give. You must not interfere with the witness's duty to tell the truth, the whole truth, and nothing but the truth. Solicitor's Conduct Rule 24.1 says a solicitor must not advise or suggest to a witness that false or misleading evidence should be given, nor condone another person doing so, or coach a witness by advising what answers the witness should give to questions that might be asked. Barrister's Rule 68 is in the same terms. If your intention is to lose the case, lose your practicing certificate, and to be charged with perverting the course of justice, then coaching a witness would be an excellent strategy. Otherwise, be careful to avoid anything that might be perceived as coaching. Now, there is one witness that you cannot conference, and that's your opponent's client. This is in fact one expression of a far broader rule referred to as the no contact rule. From the moment that you know that the other party is represented by a legal practitioner, you must not, under any circumstances, contact them directly. Never. If your opponents send you an email and they CC their client, then when you reply, you must remove the client from the CC list, because you must not ever, communicate directly with an opponent's client. This rule is so strict that I once got caught in the lift with an opponent's client in the courthouse. The client said, "Good morning," to me, and I said, "Good morning, Mr. Bloggs. How are you this morning?" The moment that we got to court, I pulled my opponent aside and told her that I had had that conversation with her client. Even such an innocuous conversation must be disclosed. Sunlight is the best disinfectant. You must not communicate directly with an opponent's client. So Solicitors Conduct Rule 33.1 says a solicitor must not deal directly with the client or clients of another practitioner unless the other practitioner has previously consented, or the solicitor believes on reasonable grounds that the circumstances are so urgent as to require the solicitor to do so, and that dealing would not be unfair to the opponent's client. Barrister's Rule 51 is in the same terms. Last but not least is the very unusual principle that you must not discuss the evidence of a witness under cross-examination. This rule can stop you from even talking to your own client. The rule makes much more sense if I explain it to you with an example. Let's say my client is being cross-examined. The cross-examination starts about an hour before stumps on the first day of the trial. An hour later, the judge adjourns. My client is still under cross-examination. It would be most unfair if I could then spend time with my client in the office that evening, going over the answers they've given, analysing the strategies being used by the other side, and preparing them for the next round of questions. Most unfair. And so in that situation, I need to say nothing. You'll need to prepare your client for this or other witnesses. You tell them, if your evidence isn't finished at lunchtime, I'm going to have to ignore you at lunchtime. I'm not being rude. It's a rule that we have to follow while you're in the middle of cross-examination. If you do have to talk to the client, let's say they're from out of town and they need directions to their hotel, then the best way to do this is to grab your opponent or another legal practitioner on their team and ask them to accompany you while you speak to the witness. That way there can be no suggestion that you've given them any guidance in relation to their evidence. All right, that brings us to the end of a monster video, the biggest video in the week with the most videos. In this video, we've been talking about witnesses and the ethics of handling witnesses. We've talked about the fact that witnesses are compellable and that they owe their duty to the court, not to any party. We've talked about the principle that there's no property in a witness. We know that it's perfectly okay to conference a witness and to draft their affidavit for them, but under no circumstances is that allowed to cross the line into coaching. It must always be their evidence. We know that you may never, under any circumstances, communicate with your opponent's client about substantive matters, and we know that you may not communicate with a witness who is under cross-examination. And we still have one video to go. In the final video this week, we'll look at the role of a prosecutor and the special ethical provisions that bind prosecutors.